After more than 25 years handling Arizona probate disputes, I've noticed something. A simple, uncontested case usually wraps up in about 6 months. But when a case drags on for years, it's usually not because the court is slow. More often than not, it's because people create legal problems that the court has to resolve. Let me show you 3 recurring patterns that I've seen over the years. Like I said, a straightforward, uncontested Arizona probate typically closes in around 6 to 8 months. That's assuming the personal representative is working to get things done as fast as possible. However, sometimes a probate case can stretch on for years. When that happens, it usually comes down to one of 3 recurring patterns. First, a dispute over who should be in charge of the estate. Second, a dispute over who should inherit. And third, a personal representative who stops moving the estate forward. Those 3 patterns account for most of the delays I've seen in my legal practice. Understanding which one applies to a given case is the first step towards addressing it. So let's start with the first pattern, the dispute over authority, because that one often takes shape before any real administration work even begins. The first fork happens before anyone touches a single estate asset. In Arizona, probate can be informal or formal. One of the first ways a probate case can get delayed is a dispute over who should be in charge. What are they contesting at this stage? Authority, who gets to act for the estate. You'll see competing petitions where 2 or more people ask to be appointed. You'll see objections to the nominated personal representative. You'll see arguments over statutory priority, which is the legal order of who has the strongest claim to serve. And you'll see qualification challenges, where someone argues a person isn't fit to serve at all. The practical consequence is straightforward. Administration stalls before it even begins. Nobody is paying bills, selling property, or settling accounts because the parties are still disputing who holds the authority to do those things. Months can pass without meaningful progress simply because the question of who's in charge hasn't been resolved. That dispute at the front of the case shapes everything that follows. A related situation arises when someone files a petition to remove the personal representative. In other words, the court has already appointed a personal representative, but now someone is filing a petition with the court to remove that person. When that happens, Arizona law restricts the representative's authority while the petition is pending. The person who is running the estate can no longer act freely. The challenge in this situation is that the world doesn't stop just because there's a dispute over whether the personal representative should be removed. Bills continue to accumulate. A house still needs its loan and taxes paid and its insurance maintained. A family business still needs decisions made. Rental properties still need managing. When the person responsible for handling those things has no authority while a dispute works through the court, the estate faces a real practical problem. Assets require attention, but the personal rep no longer has authority to provide that attention. Insurance can lapse. Property can deteriorate. The house can go to trustee sale. The delay isn't just time on a calendar. It represents genuine risk to estate assets while the underlying dispute is being resolved. The second category involves disputes over who should inherit. These tend to be the most time-consuming. Here you get will contests, claims of undue influence where someone argues the deceased was pressured into signing their estate plan, claims of lack of capacity where someone argues the deceased didn't understand what they were signing. You get allegations of financial exploitation, questions about forged or lost wills, ownership disputes over who actually owns a particular asset, and interpretive disputes over what the estate documents mean. When any of these arise, the typical litigation extends for well over a year. That process can require discovery, where each side requests documents and written answers. It can require depositions, where people testify under oath before trial. It can require mediation, evidentiary hearings, and sometimes a full trial. Each of those steps takes time and generates legal fees. A case that might have closed in several months can go on for years when the administration becomes contested litigation. One situation that can greatly complicate the estate administration is when one of the heirs or beneficiaries is living in the decedent's house. The longer that goes on, the longer that the litigation will go on. It's kind of like a cancer. The person living in the house is paying for maintenance and probably taxes and insurance on the place. The longer that goes on, the more money that they claim they deserve to get reimbursed. However, the estate has a claim for the fair market rent of that person living in the house. Now, there's a dispute over what the fair market rent should be. Should the person living in the house even have to pay for rent, or were they providing a service by maintaining the property and preventing squatters from moving in? Again, the longer that situation exists, the more difficult it is to resolve it. One thing worth understanding is that a single inheritance dispute can create additional legal issues that the court also has to resolve. A good example is a no contest clause. A no contest clause is designed to discourage someone from challenging a will by providing that they may lose their inheritance if they do. But under Arizona law, a no contest clause is not enforceable against someone who had probable cause to bring the challenge. And the important question is whether probable cause existed at the time the challenge was filed. So imagine that a beneficiary files a will contest despite a no contest clause. Now, there may be two disputes instead of one. The first is the underlying will contest, perhaps a claim of undue influence or lack of capacity. The second is whether the beneficiary had probable cause to bring that challenge in the first place. That second question can become its own contested issue, requiring evidence, briefing, and potentially a hearing. So what began as one dispute has now produced another dispute that the court has to resolve. That's something I see repeatedly in probate litigation. One contested issue can create additional legal questions, and each new question can add more time and expense before the estate can finally be resolved. And I'll also say that the longer the dispute goes on, the more issues that come up. Litigation cases have a way of feeding on themselves. The third category involves situations where the personal representative stops moving the estate forward. This happens for a range of reasons. Some representatives fail to sell assets that need to be sold. Some communicate poorly or infrequently with beneficiaries. Some cross into self-dealing, using estate resources for personal benefit. Some fail to account for estate funds, leaving beneficiaries without a clear picture of what happened to the money. Some breach their fiduciary duty by not acting in the interest of all beneficiaries. And some make premature distributions, releasing funds before debts and taxes are properly settled. A useful observation here is that many disputes in this category don't begin with misconduct. They begin with silence, and silence creates suspicion. Beneficiaries send messages that go unanswered. Months pass without any update on the estate. In that absence of communication, concern grows. People begin to assume the worst, and eventually someone retains an attorney. Litigation that might have been avoided with consistent, transparent communication becomes necessary. Poor communication is often the first step toward a formal dispute, even when no wrongdoing has occurred. When a personal representative has stopped moving an estate forward, the practical consequences don't remain abstract. Eventually, the estate faces a concrete, time-sensitive need. A mortgage goes unpaid and the property faces foreclosure or trustee sale. A structure deteriorates because no one has arranged maintenance. An insurance policy lapses, leaving a valuable asset unprotected. These situations require action, but the underlying dispute over authority or administration may not yet be resolved. When that happens, there is a practical tool available. A special administrator can be appointed by the court with narrow, specific authority to address the urgent need while the larger dispute continues. That might mean paying a mortgage, maintaining insurance coverage, or selling a property. The special administrator's authority is limited to what the court defines. The appointment doesn't resolve the main dispute, but it allows the estate's most pressing needs to be addressed while that dispute works through the process. Recognizing when an estate faces an urgent need and requesting appropriate court intervention is part of managing a contested case responsibly. When a real dispute exists, the most effective way to keep administration moving is to address the dispute itself directly. Taking a contested case all the way through discovery and trial can take considerably longer and cost considerably more than resolving the dispute earlier. In many cases, mediation, or what the court calls a settlement conference, offers a more efficient route. Mediation or a settlement conference brings the parties together with a neutral facilitator whose role is to help them reach a workable agreement. It can be applied to most categories of probate dispute. Questions about who should serve as personal representative, questions about who should inherit, concerns about how the representative has handled the the estate, and disagreements about how documents should be interpreted. Not every dispute resolves through mediation. Some require a judge to decide. But when parties do reach a resolution, even a partial one, estate administration can resume, bills get paid, assets get sold, the estate moves toward closing. Resolving the underlying conflict is what allows the legal process to move forward again. So to conclude, when a probate case drags on for years, it's often not because the probate process itself is slow, it's because a legal problem has come up that needs to be resolved. Who should be in charge, who should inherit, or whether the personal representative is properly administering the estate. If you recognize one of these problems developing in your own family, that's often the point when it's worth getting experienced legal advice rather than simply waiting and hoping the problem resolves itself. If you'd like to learn more about Arizona probate, visit probatemadesimple.com. I'm attorney Paul DeLogrie. Thanks for watching.